Hello, 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 and welcome to my YouTube channel. Thanks for watching. Please make sure you like, comment, share, and subscribe, and hit the notification button so you don't miss any of my videos. I bring hot topics and celebrity crime to you guys, and I am going to read the filing from Will Wooten, who is the district attorney in the case against Ernesto Williams, Shirley Strawberry's ex-husband. Shirley Strawberry is the co-host of Steve Harvey on the Steve Harvey Morning Show. And Ernesto is in deep poop, allegedly. Let's get an update. In the Superior Court of Fulton County, State of Georgia versus Ernest Williams, aka Ernest Lavelle Williams, aka Nesto. Case number 24SC001723. Judge Eric Dunaway. So we knew Big Sean Hoover, Nesto's attorney, had filed a document in response to the motion to suppress illegal search and seizure of his F-350. He filed that on January 6th, but he hid the document. So we didn't know what it said. But when Will Wooten filed his response or motion to dismiss the defendant's motion to suppress vehicle search for lack of standing, he included Big Hoove's filing in his filing. So now we can see all. Okay? All right. So this is the state's motion to dismiss defendant's motion to suppress vehicle search for lack of standing comes now the state of Georgia by and through the undersigned counsel and moves this honorable court to dismiss the defendant's motion to suppress vehicle search on grounds that the defendant lacks standing to challenge the search in question. The defendant filed his motion to suppress on September 30th, 2024, and the state filed a response on October 25th, 2024. A partial hearing was held on December 18th, 2024, and the court heard testimony from Roswell Police Department Detective Natalie Fields, an argument from counsel related to whether the seizure of the Ford F-350 vehicle was lawful under the Fourth Amendment. At the conclusion of the testimony and argument, the court directed the parties to file supplemental briefing related to what, if any, of the state's evidence would constitute fruit of the poisonous tree if the court ultimately ruled that the seizure of the Ford F-350 was unlawful. The state requested that the court also allow it to file supplemental briefing on the issue of whether the seizure of the Ford F-350 vehicle was lawful, in addition to supplemental briefing on to the fruit of the poisonous tree issue, and the court permitted the state to do so. Accordingly, the state now files this motion to dismiss the defendant's motion to suppress vehicle search for lack of standing. Footnote 1. In addition to this motion, the state intends to file a particularized response to the defendant's supplemental brief to suppress vehicle search and all derivative evidence on or before February 3rd, 2025, as directed by the court. Doom, doom, doom. But wait, there's more. So Will Wooten's going to file more. A particularized response. God dog. All right, introduction. The Fourth Amendment guarantees that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. U.S. Constitution Amendment 4, emphasis added. Since the ratification of the Constitution, courts across the nation have worked to define and refine the scope and meaning of unreasonable searches and seizures and under what circumstances Fourth Amendment protections apply in the first place. Over time, several fundamental principles have emerged of particular relevance here. In order to claim protections guaranteed by the Fourth Amendment, a defendant must demonstrate first, that he exhibited an actual subjective expectation of privacy in the thing or place searched, and second, that the expectation is one that society is prepared to recognize as reasonable. Katz versus United States, 389 U.S. 347, 361, 1967, Harlan J. concurring. Where a defendant cannot establish both a subjective expectation of privacy and a legitimate objective expectation of privacy, His own Fourth Amendment rights are not infringed, and he has no standing to contest the legality of a search. See generally Rackus versus Illinois, 439 U.S. 128, 1987. 1987. See also Brisbane versus State, 233, Georgia, 339, 345, 1974. Here, the defendant asks the court to recognize as objectively reasonable and legitimate a purported expectation of privacy in a Ford F-350 vehicle procured by him solely through a years-long fraudulent and bigamous marriage. Courts in Georgia and elsewhere have soundly rejected Fourth Amendment claims in similar contexts, including those involving searches of stolen vehicles, searches of hotel rooms procured by fraud, searches of laptops purchased with stolen credit card information, searches of storage units rented using false identities, and even apartments rented under false identities and forged proof of income documents. In line with these decisions and as set forth more fully below, the court should reject the defendant's Fourth Amendment claim and dismiss his motion because he has no standing to object to the search of the Ford F-350. Well, there y'all go. Come on. Now, if the judge were to rule that all the evidence obtained during this search is illegal, that would mean it's okay for Ernesto to be a bigamist. It's okay for him to have put this truck in Shirley's name and ride around with all of this incriminating evidence. Come on, Judge Dunaway. Don't let me down. Don't let me down. You know, I'm sure more shocking things have happened in the courtroom, but I seriously doubt, knock on wood, that Judge Dunaway would throw out the search evidence. I doubt he'd throw it out, but hey, that's my opinion. Y'all let me know what y'all think. If y'all have, knowledge of court proceedings, legal matters. My background is in education. I'm a former educator, maybe going back into education. So I can't, speak on this. All right, relevant factual background. On July 7th, 2022, Roswell Police Department officers seized a Ford F-350 vehicle after placing the defendant under arrest on multiple outstanding warrants. A search warrant was obtained to search the vehicle the following day, and the vehicle was subsequently searched. The search yielded multiple items, including a black book bag containing various documents, a laptop computer containing CP, let me not say CP. Let me try to read what it says without getting demonetized. Child actual ABUSE material, cellular telephones, that's plural, a USB drive, vehicle and storage unit keys, 2 black dildos, a black mask with zips. They killed me. Always having to say the mask had zips on it. I know they have to be detailed, but when you put the zips on there, it's like, hey, you got the upgraded black mask. It comes with zips. When you want them to respond, when you want to hear what they have to say clearly, you don't have to pull the mask down. You can unzip it. What'd you say? Zzz. That's what I thought you said. Zzz. And a liquid Viagra. Defendant's supplemental briefing at 4 and 5. It is undisputed that the Ford F-350 in question was not registered to the defendant, but instead was registered to Shirley Strawberry. See defendant's motion to suppress at 2. Officer Fields obtained search warrant for a white Ford F-350, tag RUR 4559, VIN 696, registered to Shirley Strawberry. The defendant asserts that Shirley Strawberry as his wife on the date of the seizure of the Ford F-350, but any purported marriage between the defendant and Miss Strawberry was bigamous and therefore void as a matter of law. In order to be able to contract marriage in Georgia, a person must have no living spouse of a previous marriage. OCGA 1932A3. Marriages of persons unable to contract shall be void. OCGA 1935A. As such, a previous undissolved marriage renders void an attempted second marriage. Lovett versus Ziegler, 224, Georgia 144, 145, 1968. Let me read footnotes 2 and 3. Footnote 2, for reasons unclear to the state, the defendant's supplemental brief to suppress vehicle search and all derivative evidence filed on January 6, 2025 does not appear on the public docket, associated with this case, even though no sealing order has been sought or entered as to any pleading filed in this case. So why did you hide it, Big Hoove, huh? Why'd you hide it? Because Georgia law presumes that the public will have access to all court records. Atlanta Journal versus Long, 258, Georgia 410, 413, 1988. The defendant's pleading is attached hereto as Exhibit A. So you hid it for no good goddamn reason besides worrying about YouTube. But I included it here in my document. Exhibit A. All right. Footnote 3. COCGA 248821. Without offering the same in evidence, either party may avail himself or herself as allegations or admissions made in the pleadings of the other. All right, I ain't quite understand that, but maybe y'all can understand it. All right. Here, the defendant remained in at least one previous undissolved marriage at the time of his attempted marriage to Shirley Strawberry, rendering that attempted marriage void ab initio. On October 22nd, 1985, the defendant married Edith Miller. Ooh, y'all, if y'all, I need to get those noise canceling headphones. I'm so sorry if y'all hear it. It's raining outside and the hubby is snoring. He needs to move. I'm just kidding. All right. So on October 22nd, 1985, the defendant married Edith Miller in Aiken County, South Carolina. See Exhibit B, Aiken County Marriage Certificate number 157831. Yeah, how old was Nesto then? Nesto was 20 years old. There appears to be no record that the marriage to Miss Miller was ever dissolved. On September 1st, 2001, the defendant married Martha Halliburton in Cobb County, Georgia. See Exhibit C, DeKalb County Marriage License number 213875. On December 16, 2014, while Miss Miller and Miss Halliburton were still living, and while at least one of their marriages to the defendant remained undissolved, that was both. The defendant fraudulently swore to and filed a marriage license application with the Fulton County Probate Court, falsely stating under oath that each of his 3 prior marriages had been dissolved. So they noted 3 prior, but they didn't name Carol Lamar, his third wife. I wonder if she reached out to the courts. I don't know. I am curious because I know Real Talk Bougie pointed it out that they didn't mention Carol. And I believe him and Carol got divorced around 2011 or 12-ish, something like that. And at the time, he was still married to his first 2 wives. God, though. Don't quote me on the divorce year, but that date is just in my brain somewhere. I know they were dissolving the marriage around that time. Okay. All right, so Miss Miller and Miss Halliburton were still living, and while at least one of the marriages to the defendant remained undissolved, the defendant fraudulently swore to and filed a marriage license application with the Fulton County Probate Court falsely stating under oath that each of his 3 prior marriages had been dissolved by divorce and that he was not subject to any legal impediment or other reason he should not be married. See Exhibit D, Fulton County Marriage License Application Number 2014-6319. See also Indictment at 22. The defendant then subsequently attempted to fraudulently marry Shirley Strawberry on January 9th, 2015, his 50th birthday. Right? Yeah. In violation of OCGA 1932A3 and 1935A, Georgia civil statutes rendering bigamous marriages void, and in violation of OCGA 16620A, Georgia's criminal statute making it a felony offense to enter into a bigamous marriage. See Exhibit E, Fulton County Marriage Certificate 2015-00423, and see also Indictment at 22. So we got the license there, we got all the documents, and then it's included in his indictment. Okay. Let me read the footnote. Footnote 4. It is unclear to the state whether a third undissolved marriage existed at the time of the attempted marriage to Miss Strawberry, but given the still undissolved marriages to Miss Miller and Miss Halliburton, the existence of a third undissolved marriage is immaterial. Yeah, that's because it was dissolved already when he got married to Shirley. Okay. Years later, on December 29, 2021, the defendant's marriage to Miss Halliburton was dissolved by divorce. See Exhibit F, Final Decree, Cobb County Superior Court Case number 21-1-7198-49. On April 17, 2024, Ms. Strawberry filed to dissolve her marriage with the defendant by divorce. Thank God. See Exhibit G, Complaint for Divorce and Other Relief, Fulton County Superior Court, case number 24CV004912. The defendant's marriage to Ms. Strawberry was dissolved on September 30th, 2024. Hallelujah. See Exhibit H, Final Judgment and Decree of Divorce, Fulton County Superior Court, case number 24CV004912. Notably, the divorce decree pointed out that the defendant and Ms. Strawberry had no joint marital assets subject to equitable division, and noted that the defendant did not file an answer or otherwise respond to Ms. Strawberry's complaint for divorce. You big dummy. The defendant apparently made no claim of ownership of the Ford F-350. The court ordered that Ms. Strawberry shall be entitled to exclusive ownership of any personal property titled in her name or in her possession. ID at 3. Ms. Strawberry was also awarded sole exclusive use and possession of the vehicle currently in her possession. ID at 1. ID at 4. So if Nesto had disputed or contested the divorce and said, the F-350 belongs to me, then he might have had a shot in the dark. Dang, Ernesto. God, dog. Further, the state expects Ms. Strawberry would testify, that 1, the defendant purchased the Ford F-350 and registered it in her name without her knowledge or consent. 2, the Ford F-350 was purchased using Ms. Strawberry's funds. 3, Ms. Strawberry continues to make payments on that Ford F-350 despite not having known at the time of purchase that it was purchased and registered in her name. 4, Ms. Strawberry was unaware that I keep getting tricked up on the defendant. Need to do some exercises. Ms. Strawberry was unaware that the defendant was still married to Miss Miller or Miss Halliburton at the time of the wedding ceremony on January 9th, 2015. 5. Miss Strawberry would not have married the defendant had she known he was still married to Miss Miller or Miss Halliburton. And 6, the Ford F-350 would not have been purchased and registered in Miss Strawberry's name without her knowledge or consent using her funds had she known the defendant was still married to Miss Miller or Miss Halliburton at the time of their wedding ceremony on January 9th, 2015. Accordingly, the defendant's use of the Ford F-350 on July 7, 2022 was procured solely through knowing and intentional fraud committed by him vis-a-vis his bigamous marriage to Miss Strawberry and his purchase and registration of the Ford F-350 in Miss Strawberry's name using her funds without her knowledge or consent. In light of that ongoing fraud, and as set forth more fully below, the defendant had no legitimate expectation of privacy in the vehicle and as a result, no standing to challenge the validity of the search of it. So Nesto, if you were quicker than that and you would have said, hey, Shirley, go get that truck. It's in your name. Tell him it's not okay to search it. If he had done that instead of trying to call his attorney, he would have been cool. If he would have said, I need to call my wife, call Shirley. Shirley, you and Dion come get the truck. Nesto, you got to be quicker than that, boo. Argument. The Fourth Amendment to the United States Constitution guarantees that the right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. U.S. Constitution Amendment 4, Fourth Amendment rights are personal rights that may not be asserted vicariously. Raucus 439 U.S. at 133, and a defendant challenging a search or seizure as unreasonable must establish standing, i.e. a proprietary interest in or legitimate expectation of privacy regarding the place searched or evidence seized. Burgesson v. State, 267, Georgia, 102, 105, 1996. As such, to prevail on a claim that law enforcement conducted an unconstitutional search under the Fourth Amendment, a defendant must first establish that he had a legitimate expectation of privacy in the place searched or evidence seized that society is prepared to recognize as reasonable. Raucus 439, U.S. at 133 through 34. See also California versus Ciriolo, 476 U.S. 207, 211, 1986. Standing to challenge search requires a subjective expectation of privacy that society would recognize as legitimate. Okay, not legitimate, Nesto. Further, it is the defendant who bears the burden of establishing both a subjective and an objective expectation of privacy. Raucus 439 U.S. at 131. Stinsky versus State, 281, Georgia, 783, 783, 784, 2007. Finally, whether society is willing to recognize an expectation of privacy as legitimate is a question of law. United States versus McKinnon, 814, F2D, 1539, 1543, 11th Circuit, 1987. Georgia courts have routinely rejected the proposition that society is prepared to recognize any legitimate expectation of privacy and property that is stolen or procured by fraud. In Burgesson, a defendant was convicted of offing a victim and stealing the victim's vehicle, 267 Georgia at 102, 103. Sometime after the offing, police located the defendant and her cohorts driving the victim's vehicle, initiated a traffic stop, and conducted a warrantless search of the vehicle, ID at 105. The Supreme Court of Georgia affirmed that the trial court's denial of the defendant's motion to suppress the search of the vehicle, holding that the defendant had no standing to assert a violation of her Fourth Amendment rights because she had no proprietary interest in the vehicle or a legitimate expectation of privacy regarding the vehicle or its contents. She tried it. ID, on the contrary, the court observed, as one knowingly using a stolen vehicle on a public roadway, the defendant probably was in constant expectation of intrusion by the authorities. ID at 105, 106, citing Brisbane, 233, Georgia at 344. See also Thomas versus State, 274, Georgia, 156, 160, 2001. No legitimate expectation of privacy in stolen vehicle. In Brisbane, the Supreme Court of Georgia again held that a defendant has no standing to challenge the search of a stolen vehicle, relying on language from an Emory University School of Law Journal article observing that one in unlawful possession of a stolen vehicle should be in no better position to assert a claim of invasion to his privacy with respect to the search of the vehicle than would be a trespasser on real property. 233 Georgia at 344, 345, quoting Gutterman, a person aggrieved standing to suppress illegally searched evidence in transition. 23 Emory LJ 111, 128 in 1974. The court followed the same logic in Sanborn versus State 251 Georgia 169, 169, 170, 1983. Like in Burgesson and Brisbane, the court held that a defendant's challenge to the lawfulness of a vehicle search must fail because defendant and his companion would have had no legitimate expectation of privacy in a stolen car. Duh. ID at 169. See also Tisdall versus State 158 Georgia App 852, 855, 1981. No legitimate expectation of privacy in a stolen vehicle. Mahar versus State, 137, Georgia, APP, 116, 120, 1975. Same. They must have a real quick system to pull up these cases now. Well, we was probably like, brr, brr, illegal search, brr, illegal seize, brr, case. Gotta love technology, right? Georgia courts have not limited this logic to stolen vehicles, but have also extended it to other circumstances where a place searched was procured by a defendant by fraud. In State versus Del Vecchio, the Court of Appeals of Georgia agreed with the prosecution's argument that one who obtains a hotel room by presenting a fraudulent credit card has no reasonable expectation of privacy and therefore lacks standing to challenge a search of the hotel room. 301, Georgia App 560, 2009. The court acknowledged that while registered guests of a hotel room can have a reasonable expectation of privacy in their room, one who obtains a room by fraud can have no reasonable expectation of privacy in the room. ID at 562. Like one in possession of a stolen car, mere unlawful possession of a room does not alone warrant a reasonable expectation of freedom from governmental intrusion. ID citing Brisbane 233, Georgia at 344, cleaned up, whatever that means. Numerous federal cases are in accordance. In United States versus Cayman, the defendant purchased a laptop computer using stolen credit card information. That's close to Nesto's situation. Yeah, Shirley paid for that with her credit card. Yeah, good try, Nesto. Good try. 404 F3D 1196, 1197, 9th Circuit, 2005. Police conducted a warrantless search of the laptop, which was found to contain images of boys who were around 10 or 12 years old, exhibiting their blankety blank for the camera. ID at 1198. The defendant's challenge to the warrantless search of the laptop was flatly rejected because, as the district court found, Cayman obtained the laptop computer by fraud. He had no legitimate expectation of privacy in the contents of the hard drive. ID at 1201. In reaching its conclusion, the court noted, "We see no ground on which to distinguish property obtained by fraud from property that was stolen by robbery or trespass." In United States v. Johnson, the defendant directed his girlfriend to rent a storage unit using a stolen identity. 584 F3D 995, 996, 10th Circuit, 2009. Police conducted a warrantless search of the storage unit and located 2 firearms, which the defendant was prohibited from possessing because of his status as a convicted felon. ID. The 10th Circuit forcefully rejected the defendant's challenge to the warrantless search, finding that the defendant had no Fourth Amendment rights in a storage unit procured by fraud. Ultimately, what matters is not whether Johnson might have some legitimate property interest in the storage unit, but whether Johnson's interest is one that the Fourth Amendment is intended to protect. Arguments such as those Johnson advances here do not distract us from the fact that a fraud was perpetrated and the victim was a third party. We will not be a party to this fraud by legitimizing Johnson's interest in the storage unit. Therefore, whatever subjective privacy expectations Johnson had in the storage unit were not expectations that society is prepared to recognize as objectively reasonable. Johnson thus does not have any Fourth Amendment rights in the unit and could not expect that the police were required to obtain a warrant or establish an exception to that requirement in order to search the unit. You got that, Nesto? ID at 10:04 cleaned up. Other similar challenges to warrantless searches have been rejected where a hotel was searched without a warrant after the defendant obtained the hotel room using a false name and a dead woman's credit card. United States versus QNAG, 386 F3D 888, 9th Circuit 2004. Defendant could not have a reasonable expectation of privacy in room he obtained through misstatements, lies, fraud, and forgery, where a vehicle was searched without a warrant after the defendant provided a false social security number on loan documents for the vehicle and stopped making payments on the vehicle. Newman versus United States number 20 CR 19 -1-JPS 2020, U.S. District Lexus 126160 Edie, Wisconsin, I guess, July 17, 2020, where an apartment was searched without a warrant after the defendant rented the apartment using the name of a deceased individual, provided a forged driver's license, and provided a forged tax return to demonstrate his ability to pay rent. God, no. After you get in an apartment after doing all that, what did you do to to blow your cover where they had to come search your apartment? I mean, dang. You went the full mile to get an apartment and then muck up. Okay, never mind. United States versus Rig Maton number CR 08-814-PHX-DGC 2013 U.S. District Lexus 65633 D, Arizona, April 5th, 2013, where a hotel room was searched without a warrant after the defendant and accomplices rented the room under a false name using stolen credit card information. United States versus Wakung 845 F supplemental 1548 1563 1994. The defendants abandoned any legitimate expectation of privacy the moment they attempted to perpetuate a fraud. Returning to Katz and its progeny, the question before this court is whether society is prepared to recognize as objectively reasonable and legitimate the defendant's purported expectation of privacy in a Ford F-350 that came into his possession only because of a years-long fraudulent and bigamous marriage to Miss Strawberry, and that he purchased and registered in her name using her funds without her knowledge or consent. As a starting point, it is axiomatic that the act of bigamy itself is one that modern society is not and never has been prepared to recognize as legitimate. Beginning as early as 1604, King James I, God, he went all the way back to 1604, y'all. King James I assented to an act of the English Parliament creating the felony offense of bigamy. If any person or persons being married do at any time after marry any person or persons, the former husband or wife being alive, that then every such offense shall be felony. Edward Coke, Institutes of the Laws of England, Chapter 27 at 88, 4th edition, 1669, modern spelling used. Indeed, as the Supreme Court of the United States long ago observed, we think it may safely be said that there never has been a time in any state of the Union when polygamy has not been an offense against society, cognizable by the civil courts and punishable with more or less severity. Reynolds versus United States, 98 U.S. 145, 165, 1878. And the Georgia Code follows suit, OCGA 19-3-2A3 and 19-3-5A, established that bigamous marriages are void as a matter of law. And OCGA 16-6-20A creates the felony offense of bigamy. See also Georgia Code Part 2, TIT 2, Chapter 1, Article 1, 1653 through 1657. In 1861, bigamous marriage is void pursuant to first codification of Georgia law. Georgia Code Part 4, Title 1, 4415 to 4416, 1861, bigamy, a felony pursuant to First Codification of Georgia law. You're busted, Nesto. It's a wrap. Moving past historical precedent, the real-world consequences of the defendant's fraudulent and bigamous marriage suffered by Miss Strawberry, and indeed the same consequences suffered by any unwitting spouse victimized by a bigamous marriage, should not be lost in this court. Not only did the defendant's actions constitute a gross violation of Miss Strawberry's trust and create the potential for lasting emotional harm and embarrassment, but the potential legal consequences for Miss Strawberry's similarly situated victims are innumerable. The federal government has previously identified a total of 1,138 federal statutory provisions classified to the United States Code in which marital status is a factor in determining or receiving benefits, rights, and privileges. U.S. General Accounting Office, GAO-04-353R, Defense of Marriage Act, update to prior report, January 23rd, 2004. He has a link here. These benefits, rights, and privileges under state and federal law include, among others, federal income tax benefits, state income tax benefits, family hospital visitation rights, next of kin status for emergency medical decisions, tax-free transfers of property between spouses, family violence protections, and various spousal privileges in court proceedings. So y'all know if something would have happened to Shirley, Sheridan would have been, what is it called, SOL? Ish out of luck. Thank God he got busted. Thank God. And I can guarantee you, if any of his other wives had passed on, he would have been the first person there trying to claim all of their assets. Oh, Lord. Simply put, the defendant's fraud operated to deprive Miss Strawberry of potentially thousands of benefits, rights, and privileges tied to marital status under state and federal law. Moreover, he purchased the Ford F-350 using her funds and registered it in her name without her knowledge or consent, leaving her with the financial burden of an unwanted vehicle that she continues to pay for to the present day. The defendant fully knew, Shirley ain't paid that truck off yet. The defendant fully knew he had procured the Ford F-350 by fraud, knew that his fraud might someday come to light and terminate his access to the vehicle, and should have been in constant expectation of intrusion by the authorities by driving such a vehicle procured by fraud on a public roadway. See Burgeon 267, Georgia at 10506. As the Supreme Court of Georgia recognized in Brisbane, one in unlawful possession of a vehicle should be in no better position to assert a claim of invasion of privacy with respect to the search of the vehicle than would be a trespasser on real property. 233 Georgia at 344-45. In this case, the defendant abandoned any legitimate expectation of privacy in the Ford F-350 the moment he attempted to perpetrate a fraud. See Wei Kung 845 F supplemental at 1563. It is immaterial whether that moment was when the defendant entered into a fraudulent or bigamous marriage with Miss Strawberry, when he procured the Ford F-350 using Miss Strawberry's funds on account of the fraudulent and bigamous marriage, or when he registered the vehicle in Miss Strawberry's name without her knowledge or consent. The entire transaction from beginning to end was fraud, and in this court should not be a party to that fraud by legitimizing the defendant's purported privacy interests in the Ford F-350. See United States versus Johnson 584 F3D at 1004. Conclusion. For the reasons set forth above, the court should dismiss the defendant's motion to suppress vehicle search on grounds that any subjective privacy expectations the defendant may have had in the Ford F-350 were not expectations that society is prepared to recognize as legitimate and objectively reasonable. As a result, the defendant lacks standing to challenge the search. Sonya, you didn't know that? Big Hoove, you didn't know that? Respectfully submitted this 24th day of January 2025. Fonnie T. Willis, District Attorney, Atlanta Judicial Circuit. John W. Will Wooten. Well, I mean, that says it all, right? That says it all. So when do they meet? When do they meet again? Will Wooten includes many exhibits, which I will do a separate video going over each exhibit. I will also have to do Sean Hoover's filing from January 6th in a separate video because it is a lot of information, y'all. So I may release them in the next, day or so y'all can watch everything regarding this illegal search and seizure motion. All right, thanks for watching. Make sure you hit the like button, comment, share, and subscribe, and hit the notification button so you don't miss any of my videos. Bye.